everybody, I'm Jesse Weber, and welcome back to Law and Crime, where we cover some of the most interesting live trials in the country today. I don't want to waste any time. I want to get right into our two big cases of the day. Are you ready? Well, here we go. First one up, we are continuing our coverage in the Shawn Great case out of Ohio. As you know, we've been constantly covering this case about this accused serial killer who's on trial for multiple crimes, including the deaths of two women. He's on trial for the deaths of two women, Elizabeth Griffith and Stacy Hicks, as well as the abduction and sexual assault of a third unidentified woman we will refer to as Jane Doe. Now, what have we seen in the courtroom so far? And I'm looking at a very careful eye of the courtroom right now of our live feed. Basically, over the last several days, we and the jury have heard Mr. Great's confession tapes. That's right, he confessed to police about murdering these women, about abducting and raping this other woman. It's a really uphill battle for the defense, and we're going to talk a little bit more about what their strategy is. We believe, now again, for anybody who's following this case, it is split up into two parts. The first part, the jury has to decide guilt or innocence, and then the second part, they have to determine these sexual predator violation specifications. How heinous were these crimes? And what we believe is that his defense team is trying to get special tests done to understand their client's brain, to try to see if he suffers from a certain mental disease or defect that would prevent the jury from ultimately finding that he deserves the death penalty. We'll talk about those mitigating circumstances a little bit later on and what the defense will do for the rest of the day. So that is the Shawn Great case. But I want to switch gears because that's not the only case we're covering today. We are going to begin today our new live trial out of Tennessee. That's right, this is the William Riley Gaul case, a former Maryville College football player who allegedly stalked and killed his 16-year-old ex-girlfriend, Emma Walker, and she was a high school cheerleader. This happened back in November of 2016. It's alleged that Gaul fired 2 shots through Walker's bedroom while she slept, and that ultimately resulted in her death. Gaul was arrested, and now he is on trial. And this is another interesting case that we're covering. So what I want to do right now is we have a short report explaining more about this case. We expect opening statements today at 10 a.m. Eastern Standard Time. So we're going to probably be switching back and forth between our two live trials today. But here's a short report on the William Riley Gaul case. Take a look.
Accused in the shooting death of a Knoxville, Tennessee teen is set to begin this week. William Riley Gaul, a former Maryville College football player, allegedly stalked and killed 16-year-old Emma Walker, a high school cheerleader, in November 2016. Investigators say Gaul and Walker were involved in an ongoing turbulent relationship and allege Gaul fired 2 shots through Walker's bedroom wall while she slept, killing the teen. Gaul was arrested in connection with the killing after he tried to recruit a friend to help him discard of the murder weapon, but that friend went to authorities, according to police. Gaul is charged with 7 counts, including first-degree murder and felony murder.
What a sad case, but we are going to be covering that live here today. You don't want to miss anything from it. So let's talk a little bit more about our two live trials for the day before we begin. I want to bring in via Skype criminal defense attorney Richard Tendler. Richard, it's great to have you back here on the program.
Nice to be here, Jesse.
Good to see you. Good morning. So let's talk about the Gaul case since we haven't had a chance to really analyze it yet. We believe it's going to be starting today. What do you make of it? A really sad set of circumstances. A man who is on trial for allegedly killing his ex-girlfriend, 2 young people. What do you make of this case?
Well, on its face, it's certainly not as compelling as Shawn Great. I'm not sure anything is as compelling for the state as Shawn Great, but it looks pretty damning evidence on this kid. You've got his telling a friend that he wanted to dispose of a pistol. You have the grandfather's pistol, the grandfather having owned the pistol 2 days before and reporting it stolen the day after her murder. She was found the day after her body was found dead. So, and then you've got potentially him with the murder weapon. So on its face, it looks pretty damning against him. We'll see what the defense comes up with and what they're going to put forward. But right now, this is a kid facing life in prison, and it's going to be pretty steep battle for him.
Well, one of the more unique aspects of this case is he's not only charged with several different crimes. I'm looking at it right now: first-degree murder, aggravated stalking, theft, tampering with evidence, reckless endangerment, employing a firearm. But he's also charged with felony murder. So in other words, it's a murder attached to child abuse. But when you think of the crime of child abuse, you don't really think about it at two young people like this. So what is the prosecution getting at here?
You know, I don't know if they were trying to do an end around to not have to prove all of the elements in first-degree murder and go through all of that, and if they get them on the abuse, which was the stalking and everything that went on with it up until the point of the murder, then it's an easy way to get a conviction and secure a life sentence. You know, that's the way oftentimes, you know, the classic example where prosecutors love to do it is, you know, you got 3-4 guys stealing, you know, robbing a 7-Eleven. Somebody, one of the assailants kills the clerk, and then boom, because you're committing a robbery, you are guilty of first-degree murder, and then you can even face the death penalty. So they don't have, you know, the burden is a little bit lower. However, so I don't know if that was what they were trying to convey here.
Yeah,
I don't really
so in other words,
it.
they're saying during the commission of this child abuse, she died, he would be guilty of felony murder. That's the way that we should understand it?
That's the way I would think it, yeah. I don't think that the prosecutors really wanted, you know, I don't think it's a good move for them.
Yeah.
You know, jurors don't, you know, it's a legal argument, and in general, jurors don't like legal arguments. Sometimes they will buy it, but, you know, as a prosecutor or as a defense attorney, you're better off just putting forward a straightforward case, which they seem to have, you know, a lot of.
Well, I'll tell you this much. We covered the Tex MacGyver case. Everybody ignored the felony murder charge. That's what they ended up finding him guilty of. So, you know, that was aggravated assault that resulted in the death of another person. And now everybody's talking about felony murder. So when I see felony murder in another case, I have to talk about it. One last thing about this case before we move on to the Great case. And again, I'm looking at a courtroom feed of the Great case. As soon as we have it, we'll jump back in there. What is a possible defense for Gaul here? If he shot through the bedroom, and obviously we'll learn more details as the case starts and we'll listen to opening statements, but just reading it initially, if he fired a weapon into the bedroom, couldn't he say, I never intended to kill her, or is that a stretch, or what's the legal way you might be able to argue that?
You know, it's difficult to say, but yeah, that may be certainly one viable defense, is to say, you know, or the gun went off accidentally. I wanted to get her attention. I had no intention of killing her. I can't believe that this happened. Maybe something along those lines.
Yeah.
You know, it's interesting. You know, apparently he texted, you know, I love you, Emma. I can't be around any of that yet. It's too soon. I know you. I'm dying to be there, but understand I can't. I love you. Maybe there's something to that. That doesn't sound like a confession to me. So,
yeah,
I'm
very curious to see how that comes into the case. So again, that is the William Riley Gaul case. We will be covering that. We expect opening statements today at around 10 a.m. and we'll make sure to go to it. But I want to switch gears right now, Richard. We're going to talk more now about the Great case, the Sean Great case out of Ohio. I'm keeping a careful eye on the courtroom feed. As soon as it's live, we'll make sure to go to it. I want to start right now by playing that 911 phone call, the infamous 911 phone call from Jane Doe. It was the one that had police get to that house, rescue her, and arrest Great. So let's play that for you right now.
911, what is the address to your emergency?
4th Street, Laundromat.
What's the problem?
I've been abducted.
Who abducted you?
Sean, Great,
Where's she at now?
asleep.
Where's she sleeping at?
In the bedroom. Please hurry.
Does he have a weapon?
He's got a taser.
Are you tied up now?
Yeah, but I kind of freed myself. Are they on the way?
Yeah, we have officers we're sending.
Please send them up.
Hey, if you're worried you don't have to talk, you can just set the phone down, okay? I you need to hear if the officers find you or not.
Oh, shit. I woke him up.
I just set the phone down. Okay, can you get to the door where you can see out? Huh? Can you get out of the house?
Locked.
It's locked. Are you at the door?
Yeah, I am.
She's at the door.
Come on out. Hurry up. Get out here. Where is it?
I'm sleeping.
Still sleeping?
Yeah.
Okay, they have her.
He's unarmed.
He's unarmed?
Yeah.
All right. Right now. Do it. Don't do that.
Welcome back, everybody. We have a live feed in the Sean Great case and new witnesses on the stand, so let's listen in live. Welcome back, everybody. You're watching a live feed into the Sean Great case out of Ohio. And if the timing couldn't have been better about that, that's the defendant right there. You see him right there. He's accused of multiple crimes. And right now you're watching the testimony of Sarah Fairchild, who's a social services coordinator and was helping Mr. Great get back to his life. And she talked about his interactions with the victims in this case as well. So it's interesting to see and hear about what was happening before these heinous crimes were ultimately committed. Now, I want to let our viewers know that while we're in the Great case right now, in about a half hour or so, we do expect to switch gears and go into Tennessee, into the William Riley Gaul case, a young man who was on trial for shooting and killing his ex-girlfriend, Emma Walker, who was only 16 years old. We're going to jump into that case when we have it. It's a really sad case, but an interesting case nonetheless, because this man is charged with multiple crimes, including felony murder, which is something that we talked a little bit about in the Tex MacGyver case. So there's a lot of interesting things at play. Again, real quick, I'm joined with Richard Tendler via Skype, criminal defense attorney. Richard, again, we're seeing the Great case. We're learning a little bit more about what was happening. What are you listening to when you hear Sarah Fairchild, listening to what this man was doing and what he was telling her before he was ultimately arrested for these horrific crimes?
You're talking about the 911 call?
Yeah, I mean, I'm just in general listening to her testimony, Sarah Fairchild. You're hearing this woman who knew him, saw his interactions with the victims. I have to imagine she has to go through her mind and think to her second, is there something I should have done? Was there something that I saw? Do you ever see that happening where witnesses are like, I should have seen this happen?
I am sure she is thinking that, you know, what could I have done? Could I have heated something off? Now, if I'm the defense attorney, we'll see what they do, but if I'm the defense attorney, and, you know, you've got your client here at the Salvation Army trying to get help, you're going to want to draw out as much sympathy about your client as possible. And you may even go as far as to say, you didn't see anything that would have alerted you to anything being wrong, because had you known that, you know, had you realized that, you would have called the authorities, you would have done something about it.
Yeah.
This is what they're trained to do. She's a social worker. That's what she's trained for.
I know. It's fascinating to hear nonetheless, these witnesses who knew the defendant and knew the victims. It's unbelievable. So what we're going to do right now is jump back into the Sean Great case. We have a new witness on the stand. Let's listen in live.
I basically go around auditing all of
All right, everybody. They're going through a lot of witnesses so far in the early morning hours here of the Sean Great case out of Ohio. I'm joined with criminal defense attorney Richard Tendler. Richard, we talked earlier about how this case is split up into two different parts. So it's the guilt or innocence phase. We believe it might end this week. The defense didn't put on an opening statement. You think they might put on an opening statement at the end when the prosecution concludes their case? Do you think they're going to put up some sort of fight, or are they just going to wait till, hey, listen, he's found guilty, let's try to save his life with the death penalty?
The way it's looking, I think it's the latter. I think they're just going to wait until, you know, the second part of the trial. I mean, we've had absolutely, basically nothing out of that.
Because they can't stand up and say, hey, you saw the prosecution's case. There's nothing here. I like to think that there's everything here against him. So what? I mean, really, what could they do?
I mean, look, that last witness, not the dental expert that we were just watching, but the one before that, the social worker. I mean, there were a ton of questions that you could have drawn out and trying to get some sympathy about why he was there, whether she noticed anything strange or anything like that. That he was obviously there for help. So, I mean, that's compelling stuff potentially. So I certainly would have gone into that. But again, we got absolutely nothing out of these defense attorneys.
Yeah, it reminds me very much of the Donald Smith case that we covered here on Law and Crime, where defense attorneys really didn't do much, and we all know how that one ended. We have a new witness on the stand. Let's listen in live to the Sean Gray case out of Ohio. All right, everybody. So we're tracking the movements of both the defendant and the victim. That's really the main basis of the witnesses so far. I'm here with Richard Tendler. Richard, I want to talk about a different issue involved in this case. We talked about it a little bit earlier today. So let's say he is found guilty. Let's say Sean Gray is found guilty across the board, and it becomes a question, what should happen to him? That second phase about trying to find mitigating circumstances. It seems like the defense really wants to have an expert, Dr. John Fabian, testify and provide special sort of imaging on Mr. Gray's brain to show that he suffers from all these different kinds of mental diseases and defects. But does that matter, and which ones ultimately matter?
I mean, I think that definitely can matter. What you want to do is, as a defense attorney, and look, many of these death penalty cases come down to that second phase of the trial. That is the quintessential, the highest form of working on behalf of a client that a defense attorney can do. This is actually saving their life. So, not to bore you with all that, however, this is where it's going to come down to. So showing aspects about his brain that don't work the same as others can have potential effects to a juror to say, hey, this guy didn't premeditate these things. This guy, there's an explanation for what occurred. And therefore, your hope is to get one juror on there to feel bad for him, to feel sorry for him, to think, hey, let's go, let's spare his life. This was not a natural born killer. This is just simply somebody whose brain doesn't work the way ours work.
Well, I wonder if they're going to touch upon that, because we heard in Mr. Gray's confession tapes that he hopes his son, his teenage son, doesn't have this gene to be a killer. And that's an interesting statement for multiple reasons, because as you just said, maybe he wasn't born like this, but maybe he was born to have this predilection towards killing and hurting people. But then again, the other interesting aspect of it is, can you show sympathy for the defendant if he has a teenage son?
Absolutely. I mean, that son now will watch his father be killed potentially by the government. So I think they've got to bring all of that out. This is where, this case has been pending for several years. These defense attorneys will have had to have spent 95% of their time working towards anything that this defendant has done well in his life, where he's shown remorse at times, and anything medically to back it up to say, hey, this isn't all his fault. And that's where it's going to come down to.
When we watch the case, it seems like an open and shut case as of right now, but do you think there was a situation where the prosecution said, look, we're not going to take a plea deal here. We're charging you with the full extent of your crimes, and we are seeking the death penalty. It's not as if you plead guilty now, we're going to take it off the table. Do you see it as something where the state wanted all or nothing?
It's hard to say. Sadly, many of the cases of the individuals who are on death row were offered plea deals at some point, and many of them were offered a life sentence. Unfortunately, sometimes it's difficult for a defendant to get up and take responsibility and sign up for a life sentence. Right. That's a tough pill to swallow. So that may have happened here. There are some jurisdictions where prosecutors, the elected, DA says, you know what, they want life, I'll give them life. But there's other cases like this where you've got several murders, potentially 5 out there, where if they give this guy a plea of life, how are they going to justify not seeking the death penalty on someone else. I mean,
Yeah.
then you get somebody who killed maybe one person, and that one defense attorney is going to say, well, you gave the guy that killed 5 women life. Why wouldn't you give us life? So probably, Jesse, your intuition is correct that prosecutors probably said there is no plea offer here. It's all or nothing.
Bottom line, ladies and gentlemen, it's not just the law that prosecutors have to attend to. They have to look at the politics of it, the community standards of it, deterrence effect. It's a lot of different factors that go into prosecuting a case and how the case will be prosecuted. So we're going to jump back into the Sean Gray case, but we're keeping a very careful eye right now on that Tennessee case that we're going to be covering in a little bit. So let's go live back into the courtroom. All right, ladies and gentlemen, we're cutting out of the Sean Gray case because we have a live feed now in the Tennessee case of William Riley Gaul. Opening statements are happening right now. Let's go live.